if you look at today, when I talk to people about pretrial detention, people think I'm nuts when I say you can't detain people just because they've been arrested. People say, well, of course you can, they're dangerous, and they've flipped what I think people think the norms are. And so I do think that all goes back to a Supreme Court that was just unwilling to enforce the constitutional boundaries that existed. Our streets, we also have large percentages of people in the American public who are very comfortable with using prisons and policing in a very broad manner. So the United States has about 5% of the world's population, but we have between 20 and 25% of its incarcerated people. So we're really we're definitely playing above our weight in terms of the number of people that we incarcerate, and that is something that's relatively new in American history. It's really only since the 1970s that America has diverged from other countries. Before that, we looked like other Western democracies. We had about the same incarceration rate as other countries in Europe, other countries that look like us in terms of democratic commitments. And really things started to shift towards the end of the 1960s, early 1970s, when we started ramping up incarceration in America. And the dynamics were not entirely dissimilar to some of what we're seeing with the Trump rhetoric, which is basically, you had Richard Nixon in 1968 ran on a campaign that was very much a law and order. We got to take back the streets. There's a need for us to get tough on criminal law in America and punishment. And that really kicks it off. And again, he did some things where he pushed the constitutional envelope after he was elected. And the Supreme Court said, oh, okay, we're going to let you do that. So it wasn't because it didn't come out of nowhere. Homicide rates were higher at the end of the 1960s in America. And, similarly, we were looking at a time period where there were a lot of protests, and a lot of those protests turned violent, a lot of property destruction. Some of them turned to riots. Cities were burning across America in the late 1960s. And so in climates like that, people get very afraid. And when voters are afraid, they are very much susceptible to candidates who come in and say, I'm going to bring you a peaceful resolution. I'm going to give you back the kind of security that you had before all this happened. And that was the dynamic that really set off America turning to this very punitive approach to crime.
Hi, I'm Janice, and I am co-founder of Jews United for Democracy and Justice, as well as the America at a Crossroads weekly virtual town hall series. If you like this video, don't just watch. Head over to our website where you can subscribe for early access to new programs, see our upcoming schedules, and participate in our weekly live streams. You can also connect directly with our guests live on Zoom. Head over to JewsUnitedForDemocracy.org. Thanks for watching.
Well, what are the consequences of mass incarceration? Does it, in fact, reduce crime?
That's the tragic irony is, I think people have an intuition that let's, lock people away and that'll solve all problem. But 95% of the people who are incarcerated come back out, because you don't incarcerate people for the rest of their lives, no matter what they've done. And when they come back out, a long period of incarceration is often counterproductive. It makes it that much harder for people to settle back into a law-abiding life. So no, it's not. It's costs a ton of money. There's way more cost-effective ways to deal with criminal behavior. So, in fact, most of the things we do when it comes to crime and punishment in America are not only cruel, but unnecessarily expensive. And really, it's communities of color that bear the brunt of it too. The kind of racial disparities and how all of that stuff gets administered are really stark.
You talk at length in your book about 6 different cases involving the U.S. Supreme Court in such a way that you suggest that it is, in fact, well, I'll let you make the case. What about those 6 cases overall? What has the Supreme Court done with respect to mass incarceration?
Yeah, so I'll give you one example that I think is just helpful in light of what we're talking about in America today, because the parallels are pretty, you'll see the parallels. So As I mentioned, Richard Nixon ran in 1968 on this law and order campaign, and he actually was also running against the Supreme Court. A lot of people who study the court know in the 1960s there were a couple big decisions that it had that, people kind of think this the heyday of the Warren Court is that they decided a case map versus Ohio, where the court said, look, if the police obtain evidence by engaging in unconstitutional searches, you got to exclude that evidence from somebody's trial. Like that's known as the exclusionary rule. And the other case the court decided in the 1960s was Miranda, which people I think are aware of from watching TV and movies, where people are read their rights, that they have a right to counsel. And both of those cases, Mapp and Miranda, were politically not very popular in America. There were editorials written in newspapers. The police hated them, and they used the court. They basically blamed the court for deciding those cases for why there was so much unrest in the end of the 1960s. They said, part of the problem is the Supreme Court. And so in 1968, part of the campaign, people had signs on their lawn that said "Impeach Earl Warren." So the idea of the Supreme Court kind of being part of the dialogue in America and kind of what it's that's not new. So to the extent people I think now it's a big deal with the Roberts Court, it certainly was true back at the end of the 1960s. So when Richard Nixon, and he campaigned explicitly against the court, he criticized the court on the campaign trail. He promised he would appoint different kinds of justices and he would be a law and order candidate. And George Wallace, who was also running, did the same thing. So when he's elected, he realizes he has to do something about crime, Nixon. And he kind of, I think, realizes, as most presidents do, president of the United States actually doesn't really have a lot of authority over crime in America. Like their policing is local. Those kinds of policies are local. And so what he decided to do is he thought he would create this new law in the District of Columbia where you could detain somebody after they had been arrested for a crime if you could demonstrate that they were dangerous. Now, for 200 years in America, you could not do that. You're presumed innocent, right? You get a trial. And if for us to detain you because, we think you engaged in criminal behavior, we have to prove that you engaged in that criminal behavior. Now, if we want to just detain you because we say you're a danger, there's civil commitment proceedings for that. So this was going to be the first time that there was going to be a law that said, no, all we have to do is just going to arrest you for the charges, and we're going to use your arrest as the basis for locking you up. So this kind of new idea that Nixon comes up with, he asks one of his administration lawyers, William Rehnquist, who's later going to become the Chief Justice of the United States. But at that point, he's a lawyer in the Nixon administration. He helps draft this law. He drafts this law for the District of Columbia. And ultimately, it would allow you to detain someone for up to 60 days after they'd been arrested if the government could prove they were substantially likely to win their case on the merits. It was pretty limited because they knew they were testing the constitutional waters because no one thought this was okay. But they made it very limited and narrow. And ultimately, that law, it doesn't apply in very many cases because it is hard for the government to win, but it gets upheld in the lower courts. And as soon as it does, and this was Nixon's plan, it gets adopted. Other states say, hey, we should have laws like that. We should also start detaining people pre-trial by claiming that they're dangerous. And so the law spread, that idea spreads, and including at the federal level, Congress passes a law. By the time Congress passes its version, it's like over a decade later, and people had become so desensitized to detaining people pre-trial that by the time Congress passes its version of this, there's no cap on how long you can be detained. There's no requirement that you show you're likely to win on the merits of the case. And in fact, Congress creates various presumptions that say, well, you're charged with a drug crime that has a statutory maximum of 10 years or more. You're presumed dangerous. You're just presumed dangerous because you sold drugs. And so you could be detained. That law that Congress passes becomes the law that gets brought to the Supreme Court in 1987. And it's the first time the Supreme Court had ever considered, could you detain somebody on the basis of an arrest because you claim they were dangerous? And for, if you were an originalist, and I go through this in the book, I explain absolutely not, you could not uphold this. There's no way the framers would never have allowed this. The Supreme Court, in an opinion by, and you probably got gonna guess who it was by. By now, Bill Rehnquist is on the Supreme Court. He writes the opinion. And he says, yeah, it's all fine. He's like, the presumption of innocence, that's just a burden of proof thing. But this is just like a regulatory matter. The state can, if it feels like it needs to, regulate things to keep people safe. And the argument he uses for that is based on the brief filed by the government in the case, the Solicitor General's brief, the case it cites to support this idea that sometimes, you have to do things like this to prevent dangers, is this case called Korematsu. And some people might be aware of it. That's a Supreme Court case that upheld the internment of people of Japanese descent. During World War II. It's really a blight on our Supreme Court case law. The modern court has actually disavowed it and said, Korematsu was terrible. It was a terrible moment for us as a court.
It's still in effect, isn't it?
Well, the court has kind of disowned it, but it's unclear, if it hasn't officially overruled it. And so, it's kind of unclear when the court sort of said that, what it actually meant. But at the time that this case was decided in 1987, the court hadn't made that pronouncement yet. And so the Solicitor General cites it as if it's just any other case and it's fine. And that is the basis on which the court upholds pretrial detention. And, the reason I think that case is a good example for us to think about now is it was a very similar dynamic where you had a government that decided they wanted to test constitutional boundaries. They wanted to do something that had never been done before, that no one thought was legal. And, the way they did it is they started it off with this more limited law. People get used to that. Then they expand it. And then, now if you look at today, when I talk to people about pretrial detention, people think I'm nuts when I say you can't detain people just because they've been arrested. People say, well, of course you can. They're dangerous, and they've flipped what I think people think the norms are. And so I do think that all goes back to a Supreme Court that was just unwilling to enforce the constitutional boundaries that existed. The court should never have upheld that. But I think by the time it gets to the Supreme Court, the court felt pressure, to go along with what the government was saying, as the court often does. The court often, when is faced with a government argument, I think feels pressure to defer, to say, hey, the government knows best about what keeps people safe. And the other cases in the book have kind of similar backstories about deferring to the government, not wanting to second guess, even though the Constitution itself says otherwise.